For families separated by borders, time is not measured in months or years. It's measured in missed moments, missed birthdays, anniversaries, school milestones, and even final goodbyes. If you've been waiting to reunite with your spouse, your child, or your parent, and you filed a Form I-130 petition only to feel trapped in an endless USCIS backlog, then the January 2026 update may be one of the most important immigration developments you've heard in years. This update has the potential to reshape how family based petitions are processed and, for some families, significantly shorten the painful wait. That's why it's critical to understand every detail, because missing even one could mean missing an opportunity to move your case forward faster. Welcome back to Alex Morgan. This channel exists for one simple reason: to give you calm, clear, and fact based immigration updates in a system that often feels confusing, stressful, and unpredictable. Immigration news moves fast, rumors spread even faster, and families deserve clarity, not fear. Today's video is especially important because it focuses on Form I-130, the foundation of family-based immigration to the United States, and a major restructuring announced by USCIS in January 2026 that could finally bring long-awaited relief to millions of families worldwide. Form I-130, officially known as the Petition for Alien Relative, is the very first legal step in most family immigration cases. It is how U.S. citizens and lawful permanent residents prove that a qualifying family relationship exists with a spouse, parent, child, or sibling living abroad or already in the United States. Without an approved I-130, most family members cannot move forward in the green card process at all. This form does not grant a visa or a green card by itself, but it secures something just as important: your place in the immigration system through what's called a priority date. That priority date determines how long you may have to wait before a visa becomes available, especially for categories subject to annual limits. Because of this, I-130 approval timing is absolutely critical. Delays at this stage can add years, sometimes decades, to family separation. That's why any change in how USCIS processes I-130 petitions is not just bureaucratic news. It's life-changing for real families. For years, I-130 processing times have been unpredictable and painfully slow. Some families receive approvals within months, while others wait years with no explanation, no updates, and no clear timeline. These delays don't just affect paperwork, they affect lives. Spouses live on different continents. Children grow up without one or both parents present. Elderly parents spend their most vulnerable years separated from their families. Financial strain builds, emotional stress compounds, and uncertainty becomes the norm. Families often plan careers, housing, education, and even medical decisions around immigration timelines that keep shifting without warning. Because family reunification is a core principle of U.S. immigration law, advocates, attorneys, and lawmakers have long pushed USCIS to reform its approach. The January 2026 update is a response to that pressure. It represents a recognition that backlogs are not just administrative problems, they are humanitarian ones. In January 2026, USCIS announced a major restructuring of how I-130 petitions are prioritized and processed. Instead of treating all family petitions the same way, the agency introduced a tiered priority system designed to move certain cases faster while improving predictability across the board. The stated goal is clear: reduce processing times, create more consistent timelines, and eliminate unnecessary delays. Importantly, this update focuses on internal workflow changes rather than changing immigration laws themselves, which makes it faster to implement and more legally stable. What makes this update different from past promises is that it includes specific timelines, clear category prioritization, and new transparency measures. This isn't just a vague commitment to do better. It's a structured plan with measurable benchmarks, which means families can finally track progress instead of guessing. Under the new system, the highest priority is given to immediate relatives of U.S. citizens. This category includes spouses, unmarried children under 21, and parents of adult U.S. citizens. USCIS is now targeting a processing time of 6 to 8 months for these petitions, a dramatic improvement compared to the 12 to 24 months many families have experienced in recent years. Because immediate relatives are not subject to annual visa caps, The main bottleneck has always been processing speed, not legal quotas. By prioritizing these cases, USCIS is clearly signaling that nuclear family reunification is its top priority. For many families, this change alone could cut separation time in half and provide much faster certainty about their immigration journey. It is one of the most promising aspects of the January 2026 update and offers genuine hope to families who have been waiting far too long. The second tier of the new system focuses on family preference categories. This includes adult children of U.S. citizens, siblings of U.S. citizens, and spouses and children of green card holders. These categories are subject to annual visa limits, which means wait times can still be long. However, USCIS is introducing a critical shift called parallel processing. Under this approach, the agency aims to approve I-130 petitions within approximately 12 months, even if a visa is not yet available. This is a major change. In the past, families often waited years just to get I-130 approval, only to then face additional years of visa backlog. Now, earlier approval gives families certainty. It allows them to plan financially, legally, and emotionally. Knowing that your petition is approved is a powerful milestone, even if the priority date is not yet current. Another major source of delays has been requests for evidence, known as RFEs, and notices of intent to deny, or NOIDs. These requests often add months or even years to processing times, especially when they are vague or overly broad. Under the new system, USCIS is implementing proactive case development. Officers will identify potential issues earlier and request specific, targeted documentation rather than generic evidence requests. Petitioners will also receive clearer guidance from the beginning about what documents are required. This may sound technical, but its impact could be massive. Each RFE can add 3 to 6 months to a case. Reducing RFEs means fewer delays, fewer errors, and smoother processing overall. Starting in February 2026, USCIS will also begin publishing monthly public processing reports. These reports will show average timelines by petition type, filing location, and whether stated targets are being met. This level of transparency is new and powerful. For families, it means realistic expectations instead of guesswork. For advocates and lawmakers, it means accountability. When performance is visible, pressure exists to meet goals. Many families are asking what happens to I-130 cases filed before January 2026. USCIS has confirmed that pending cases are included in the new system. Older cases will be folded into the restructured process based on category and original filing date. There will be a 90-day transition period while cases are reorganized internally, and during this time, some applicants may see little or no movement. Silence does not mean denial. It often means reclassification is underway. If you are eligible to file an I-130 now, the guidance is clear: file as soon as possible. Waiting provides no advantage. Your priority date still determines your place in line, and filing early locks in your position. What matters most is filing correctly and completely. Errors and missing documents can erase any benefit gained from faster processing targets. It's also important to manage expectations. Premium processing is still not available for I-130 petitions. This update focuses on system-wide improvements, not paid fast-tracking. Limited expedited processing remains available only for true emergencies, such as severe medical or humanitarian situations, and requires strong documentation. Skepticism is understandable. Families have heard promises before. What makes this update different is specificity, transparency, staffing increases, and new technology. Together, these elements give this reform a stronger chance of success than past attempts. Waiting for an I-130 decision is not just stressful, it's deeply painful. Your frustration and exhaustion are valid. This update does not erase years of waiting, but it does offer cautious optimism. It shows recognition that families deserve dignity, transparency, and predictable timelines. If this breakdown helped you understand the January 2026 I-130 update, support the Alex Morgan community by liking this video and sharing it with others who are waiting. Subscribe and turn on notifications so you don't miss critical USCIS updates, and let us know in the comments. How long have you been waiting? And are you hopeful about these changes? You are not alone, and clarity brings us one step closer to reunification, which